Today's video covers charging decisions, specifically the scenario where an officer has multiple charges available against a suspect. I'll cover some considerations that officers should take into account when deciding what charges to submit or book on, and when officers may choose to not charge even when charges are available. I'm Steve Serbalik. I'm a panel attorney for ASCOPS in Arizona. This video is not legal advice, and I want to also offer this additional caution. Make sure that you follow your agency's policies when it comes to charging. So here's a scenario to help illustrate the concept. Let's say that you're an officer who sees a car roll through a stop sign. You turn on your emergency lights and siren to initiate a traffic stop, and the suspect takes a long period of time to actually pull over to the side of the road and stop. Once the suspect does stop, he refuses to provide an ID, and as you're at his window, the suspect spits at you, with the spit hitting your pants leg. You decide to have the suspect get out of the car, and you place the suspect in handcuffs. Once the suspect is in handcuffs, you find a wallet in his possession without any ID inside. You find out later that the suspect has a misdemeanor warrant for charges from your city. What do you do next? To review, the suspect can be booked on the warrant, and also could be cited for the traffic violation for failing to stop for the stop sign, maybe failure to yield to a law enforcement vehicle, assault or aggravated assault for spitting on your leg, and possibly operating a vehicle without an ID. Should you charge the suspect with everything or nothing, or some charges but not others? Well, this often comes down to officer discretion. Here's some advice that I'd offer. I always recommend citing for the original traffic violation, for the reason that you initiated the law enforcement contact. In this case, the rolling through the stop sign. Defense attorneys will often attack stops alleging that there wasn't a proper basis for the stop. So, in my opinion, it's a good idea to cite for the original traffic violation. Additionally, I always recommend charging aggravated assault if you are the actual victim of an assault. If someone assaults a police officer performing his or her duties, that is always aggravated assault. Even if you, the officer, aren't injured, I highly recommend booking for that charge. You shouldn't have to face being spit on or hit or otherwise assaulted at your work. And charging, when appropriate, also grants you victims' rights. Establishing that an arrest occurred for a felony, like an aggravated assault, can also help you with potential civil issues if the suspect complains or sues you later on. And again, you aren't expected to be assaulted as a condition of being a police officer. As for the other charges, if your policy allows, I probably wouldn't charge the misdemeanor for driving without an ID. This charge is often dropped, and I suspect the suspect has a license, so it's often not worth submitting this charge if you have that information. I also recommend you don't only charge for simple assault instead of aggravated assault in this circumstance in an effort to have this case heard in a lower court. Instead, book for the primary offense, aggravated assault, and also the lesser included offense, as if the main charge fails at initial appearance due to an insufficient Form 4, the lesser included charge might survive. The rule is that the IA attorney can't add to the booking, but that the attorney can work with what you give him or her. On the other hand, if the felony survives IA, the prosecutors can simply dismiss the lesser included simple assault. Finally, as to whether to charge failure to yield is very fact specific. So depending on the circumstances of the suspect's driving behavior, like whether there was some sort of evasive action taken, I would consider not submitting or booking on that charge in this instance. The rule of thumb to follow is this: issue at least the initial traffic citation when possible. If you're the victim of an assault, charge aggravated assault. For felonies that involve victims, if the victim wants to cooperate in pressing charges, if the facts support them, book on those felony charges. For crimes where the victim is the state, not a person pushing for charging, or for crimes that seem to otherwise be piling on, use your discretion, but always follow your agency's policies. Additionally, this is just a topic summary, but it's already a long video. Nothing in this video discusses domestic violence cases. Follow the law and policy as to whether to book or charge in instances of domestic violence. If you have questions or comments about this topic or suggestions for a future video, please leave your comments in the comment section below. And please share this video with other law enforcement officers that you think that it might help. Like this video so that YouTube shows it to more interested viewers, and please subscribe for more law enforcement lesson videos and click the notification bell so that you know when videos are released. This also helps the channel. Videos come out at 5:30 p.m. every Sunday, Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.